Well, good morning, everyone, and welcome to this EPC online policy dialogue on the Digital Markets Act, addressing obstacles to growth and innovation for a strong EU post-COVID recovery. So thank you for joining us and good morning to everyone. My name is Andreas Aktoudianakis and I am the lead policy analyst at the EPC working on digital files. Today I have with me an excellent panel of speakers joining us to discuss on this crucial matter of the Digital Markets Act. We are organizing this today's online policy dialogue in partnership with Google, and we are going to be looking at this issue with some renowned speakers. I'm going to introduce our speakers now, and then I will give some brief instructions about the housekeeping rules, though I'm sure that you're all used to them. So today with us, we have Mr. Tiemo Wölken, a member of European Parliament from the Socialists and Democrats, joining us. Thank you very much for joining us. Mr. Pedro Rodrigues Duarte, from the legal affairs of the permanent Portuguese presidency, and has been chair of the working parties on competition and public procurement. Then we'll have with us Ms. Vale Meunier, who's senior vice president at Compass Lexecon, and Mr. Karlsson, founder of Avocat Firman at Karlsson & Co., and Karina, EU Director of Developers Alliance in Brussels. Thank you all for joining us, and I'm looking forward to our discussion. So just a couple of remarks in terms of housekeeping rules, though these are pretty straightforward. We will be hearing first from Mr. Tiemo Wölken on the DMA and his perspective from the European Parliament, as discussed, and we will be hearing from him for about 7 minutes. Then we will listen from Mr. Pedro Rodrigues Duarte, who will offer his introductory remarks after Mr. Wölken. Then we will hear from Ms. Vale Meunier, Mr. Karlsson, and Karina. So in this order, we are going to hear from our speakers. And after this cycle of initial inputs is completed, then we are going to have a panel discussion that I will moderate. And then around 11 o'clock, we will open the floor to questions from the audience. So for all of you joining us this morning, please keep your questions coming in and share with me. Please put your questions in a short input as possible, so I can read while moderating at the same time, and I will raise your question on time. And well, without further ado and delay from my side, I would just like to offer the floor to Tiemo Wölken for his introductory remarks. Tiemo, thank you very much for joining us. It's great that you have you with us today. The floor is yours. Thank you.
Yes, thank you very much, and thanks for organizing this event. I'm happy to say a few words on the Digital Markets Act and my perspective on it. So this presentation will mostly focus, of course, on my draft report for the DMA in the jury committee, which will help the debate in the IMCO committee. Well, let's start with the obvious. The Digital Markets Act is a central building block of a fairer internet. So this is true both for the competitors of dominant platforms and for the end users. So the Commission proposal is, from my perspective, a good foundation for our work, but as always, the devil is in the detail. So my objective is a future-proof, flexible framework that doesn't become obsolete in a few years. So I want to make sure that the Digital Markets Act really fulfills its objective of empowering platforms to unlock their full potential, and at the same time allow end users and business users alike to reap the full benefits. So this is where I think we should aim for. So some see, unfortunately, the DMA only as a stopgap against the dominance of well-known US platforms. And yes, therefore the DMA is helpful. But I think that only focusing on the big dominant platforms misjudges the DMA's potential. So digital markets change at a rapid pace. New technologies can emerge and become dominant within just a few years. And I think the DMA should take the nature of the digital economy into account and not limit itself to just the 8 core platform services. So I therefore proposed to make the list of core platform services non-exhaustive in order to make the DMA future-proof. Furthermore, the next potential gatekeepers, for instance, voice assistants, are already waiting in the wings and should be covered by the DMA. So let's look into the future, not only try to regulate the status quo. So we also need to keep in mind that gatekeepers can exist in all kinds of markets. So some larger, some smaller, and not all of them dominated by the well-known companies. And I therefore ensured, in my opinion, that all potential gatekeepers are covered by the regulation and that the Commission can verify whether they hold a gatekeeping position in their market on a case-by-case basis. To this end, I propose that we streamline the designation process, which I change into a qualification process. Particularly important is that all who qualify as a gatekeeper will have to comply with the obligations of the regulation, whether they self-report or not. So the Commission should be able to grant exemptions after direct dialogue and well-substantiated arguments. And I also want to stress the importance of the ability of the Commission to designate emerging gatekeepers irrespective of the quantitative threshold as a central instrument to guarantee the flexibility of the regulation in its practical application. And regarding the obligations in the Commission proposal, many of them address the right issue, but the provisions often fall short of the full potential of their underlying ideas. And that's why I suggested several amendments to fix these issues. Most importantly, the Commission proposal only pays a lip service to the rights of end users. My proposal strengthens users and puts them on equal footing with business users of platforms. For instance, I call for more representation and rights for end users and business users in flagging non-compliance of gatekeepers. And I also want to strengthen competition, innovation, and this is very important, end user choice by imposing clear rules on interoperability. This is what I think is the key. So we need to be strong here. I complement this interoperability with stronger rules on pre-installation and default settings of apps and services, which are often abused by gatekeepers to ensure the use of their own services instead of services by competition. Furthermore, I introduced a general fairness principle for gatekeepers, and this fairness principle goes beyond specific obligations. So no matter where and how, gatekeepers should never be able to abuse their dominant position, and we should not allow any loopholes. And this is very, very, very important. So this all goes for so-called dark patterns, the suspicious manipulation of user behavior, and I also seek to ban it. And at least in Germany, it's already a lively debate on dark patterns. So I expect that this is an issue in many, many member states. So finally, I also want to put an end to the uncontrollable trade of personal data. As users, we are often forced to surrender control over our personal information entirely. Gatekeepers use our data not only for the service we register for, but combine it with data from other services. So data sovereignty of us, of the users, is unfortunately kind of an illusion. And GDPR demonstrated that consent rules do not stop this practice. If gatekeepers want our consent, they are likely to find a way to get our consent. And this is why I want to ban the combination of personal data between gatekeeper services entirely. Lastly, I propose to add new obligations for online intermediation services. And these platforms wield significant market power at the cost of the business users that depend on them, such as small businesses and generally self-employed. In order to remedy this issue, platforms in this field should be obliged to provide their business users with transparency, as well as enabling them to communicate issues and address non-compliance with the DMA or abusive practices by the online intermediation service, notwithstanding the obligations under national or union legislation. And in addition to these suggestions of my report, a major point of discussion right now is, of course, enforcement and remedies. So this is unfortunately not within the competence of jury, but it falls in the competence of the Econ Committee. So I do not want to get into too many details on that. But for me, it is clear that any regulation is only as good as its enforcement, particularly in the fast-paced tech sector. And I believe the EU shouldn't be afraid to show its teeth here. The breakup of tech companies should be part of its toolbox as a measure of last resort, particularly where companies use their market power to eliminate competitors through killer acquisitions or unfair market practices. We need to become active. So looking at the practical side of things, I think that 60 to 80 staff the Commission wants to allocate to supervise the DMA are not enough, particularly if we want this ambitious framework to be enforced properly and quickly. Instead of relying only on the Commission, we should also draw on the expertise from other authorities, such as the national competition authorities. The European Competition Network, for example, is a good example where the national authorities can assist DG Com with their expertise while still leaving practical enforcement to DG Competition. Of course, I don't know which solution Econ will discuss and come up with in the end, but I would be surprised if such a solution involving national authorities would not be on the table. So I think I spoke 1 minute longer than expected. So apologies. And yeah, thank you very much for the invitation again. I'm looking forward to the discussion. But as I said, or as I was introduced, I have to leave, unfortunately, at 10:30.
Thank you very much, Tiemo. And this is great to have you with us. Your perspective really gives our discussion a good context, and we also, have a clear, some convergence also with the issues you mentioned here. So this will be good for thought. So, the mention of a flexible framework, looking at case by case, streamlining designation processes, but also concerns about interoperability and effective enforcement. So thanks so much for these initial inputs. These are really helpful. And now I would like to give the floor to Mr. Pedro Rodrigues Duarte from the Portuguese presidency, who can offer us an overview of the issues in the progress report and maybe elaborate on some of the Compet Council policy debate. Mr. Duarte, thank you for joining us, and the floor is yours. Thank you very much.
Thank you, Andreas. Thank you very much. Good morning to you all. Thank you for inviting me to join this roundtable. And I would like just to remind you that I'm wearing today two hats. One as the Portuguese attaché for competition and state aid, and the second one as the still current chair of the Council's working party to which DMA was allocated, so the Digital Markets Act. As the proposal was adopted by the Commission last December, we knew at the presidency team that the first negotiation months would be crucial to set the tone and the pace. And it seems that our efforts have paid off. The working party worked a lot, hard, and enthusiastically during 21 meetings, 17 of which were dedicated to the DMA. I'm very happy to confirm that the presidency's main goal has been achieved, meaning that we succeeded in having a full examination of the whole 39 article text by April, what allowed us to deliver the presidency's progress report that you have just mentioned to competent ministers so that they could take good note of the progress achieved in their meeting in May. And that allowed them to have a very lively and very supportive debate. And that was a very important political moment for the future of this file. So after completing a first full examination of the proposal, we realized that there was broad support for the regulation. And as there was still some time left, we continued to work in order to build on the progress accomplished. We took the negotiation to a new level by opening in-depth discussions of the topics on which there was less consensus, which is totally normal among 27 negotiators in one of the co-legislators. And there is the second one, and Tiemo will play an important role there. But that's for later. The atmosphere was great, I have to tell you. Delegations have been offering comments and submitting proposals to amend the draft regulation. Maybe not as many as the EP's committees. At a certain point, the presidency considered that the negotiation was mature enough to come up with a redraft proposal, taking into account many of the member states' contributions and also the Commission's views on the discussions. But we have redrafted, hopefully not at the expenses of coherence and consistency, because you know that the exercise of redrafting is very demanding, because it's not only about making proposals and having into consideration different approaches. It's as a legal text, it's also about keeping the coherence and the consistency of the whole text. So on the very last meeting on the MA, on the 23rd June, we handed over a first compromise text to the next presidency, the Slovenians. And before I give you a glimpse of the work done, and without being indiscreet or breaking any rule of procedure, I would very much like, from an institutional but also personal point of view, to share with you that irrespective of all the fuss around, eventually we have reached a very good basis for further negotiation, framed by a constructive approach a smooth process, even under unprecedented conditions, and a strong vision on the substance. People are very conscious that this may be an historical piece of legislation, but no one seems to be afraid of that scenario. So before I pass the floor to my fellow panelists, let me briefly touch upon the main takings of this semester. Generally, the proposal received broad support among member states, in particular as regards the choice of fast and flexible procedures. And as I understand, it goes along Tiemo's views. Also, the combination of quantitative and qualitative criteria for the designation of a gatekeeper, and also the setting up of investigative and sanctioning powers. Not surprisingly, the presidency identified some topics that would need further discussion, which is absolutely normal, such as the role of member states and national competition authorities in the implementation of the DMA, and also the interaction between EU and national legislation with similar scope, the powers conferred on the Commission to future-proof the regulation, because as Tiemo rightly said, we cannot be reviewing the MA every 2 years. Also, some further discussion will be needed on the precise scope of the proposal, and then on the process of designating a gatekeeper, namely the so-called regulatory dialogue. Those discussions will be now steered by the Slovenian presidency, to which I wish now and here the best of luck. Thank you for listening to a chair on the verge of exhaustion.
Thank you much. Thank you very much, Mr. Duarte. This is great. Thanks so much. And it's great to hear from you about the work that you have done over the past 6 months. This presidency, as you said, had to deal with very, very important issues at a very crucial timing. So great to have you with us today. And thanks so much for giving us this important overview. And we will be following up with the work and that you have done. And I'm sure that many people will like to comment on that. And yeah. Thanks so much for this. Without further ado, maybe I'd just like to offer now the floor to Ms. Valerie Meunier, who could offer some remarks from her point of view. Valerie, thank you very much for joining us. The floor is yours. Thank you.
Thank you, and thank you very much for inviting me to speak today. At the outset, I should say that with some of my colleagues at Compass Lexecon, we have prepared a report or a paper that we just published yesterday evening on our website that concerns, issues about the DMA. And disclaimer, it was commissioned by Google, but nevertheless, the opinions that we expressed there are ours. And as practitioners in this field for many years, I think what I would like to say at the outset is that I'm not against any proposal for new tools or to regulate digital markets, But my concern and our concern is that I think the DMA has some problems with the way it approaches these issues. First, if we take a step back, why is it that we want to regulate markets? We want regulation, is there to target critical economic activities where there is no potential for competition. But at the same time, that would allow competition on other parts of the value chain. Think about telecom or energy. You regulate the infrastructure, the networks that you do not want to duplicate. There's a natural monopoly there, so you regulate the access to that infrastructure. But at the same time, regulation wants to allow competition to emerge in other places of the value chain. We're in a different situation here. We have competition. So what is the problem really? According to the DMA, either the existing competition rules wouldn't bite, wouldn't work in those markets, or for some reason, or there are issues in those markets that cannot be captured by competition rules, i.e., for example, if there are structural problems that would need to be addressed. There are other issues that are, consumer or users' behavior. Why do we stick always with the same search engine, although there are other search engines that exist? This is our behaviors as end users, and we've seen that, for example, in some of the competition, the European Commission case against Microsoft and the Internet Explorer. We see that the remedy there was, how to nudge or give incentive to consumers to change their behavior. It was not necessarily the conduct of the companies. So more generally here, some of the issues that may arise may not be related to, anti-competitive conduct of the markets in place, of the gatekeepers or the companies in the platforms in those markets. So, of course, the issue here is that digital markets and platforms, multi-sided platforms, this is very important, have some inherent traits that lead to high concentration on the market, okay? Of course, network effect, be they direct or indirect, will lead to a sort of snowball effect that will increase the size of the platform to the benefit of consumers and to the benefit of end users and business users. That's the thing. Here, you cannot have a presumption in those markets that big is bad, because you can be big, but it is what increases the value of the platform to business users and end users and all users in the platform. The bigger, the better. So size, there cannot be a direct positive correlation between the size of the platform and the fact that it will yield detrimental effects on the market, on the contrary. So what you want to do in a static perspective, you will observe big platforms. You will observe high concentration. What is important is dynamic competition. The fact that new entrants who are more innovative can enter the market and take place in the market, either at the detriment of the existing platform or coexist with it, if you manage to incentivize users to multi-home, or you allow users to multi-home. So that leads to an issue here of the definition of gatekeeper. The definition of gatekeeper here is size, absolute size. But again, absolute size might not be an issue in itself. Being big means also that the platform maximizes the value to all users of the platform. So the problem here is that as a practitioner of competition enforcement, of competition rules, here the gatekeeper designation is completely disconnected from the notion of dominance in competition law. And that is an issue. Even in competition law, being dominant is not in itself illegal, okay? Being dominant for a company is also the perspective of making profits, which ex ante means it gives incentive to that firm to invest, precisely because of the perspective of making a lot of profit later on and being, you know, the best on the market. Being dominant is not illegal. It comes with a special responsibilities, yes. It comes, of course, with the obligation to follow competition rules, to not behave in a way that would restrict competition, that would exploit consumers, that would exploit end users, directly and indirectly by foreclosing markets. And because those markets are complex, okay, they're very technical, they're very complex, they evolve very quickly. I'm a bit struck also by the willingness to want to act very quickly. I think there's a paradox here, okay? So I understand that you don't want investigations that look backward and investigations that last for, you know, 6 or 7 years. But there has to be a middle ground between very long backward-looking investigations and rules that apply across the board through a very broad brush approach that would apply almost instantaneously or only in a few months. There has to be a middle ground where you allow flexibility, where you allow a dialogue between those platforms and the regulator, or the European Commission and the regulators, and, you know, maybe the national competition as well. Somewhere in between acting in a few weeks and a few months and taking 7 years to take action. And to me, and I think to a lot of practitioners, this new competition tool that was suggested last year had a lot of traction. You know, having the ability to investigate markets on precise or a little bit more precise issues. For example, here we have, you know, for now the DMA provides a list of core services and and a list of do's and don'ts, as if those do's and don'ts would apply to any of those core services. But this is not the case. We know very well that, you know, you take Article 5 of the DMA and you can recognize the Apple rule, you can recognize the Google rules, you can recognize the Amazon rules. So in my view, it would make more sense, it would be more truthful, a little bit in the sense like the CMA in the UK is doing, you know, let's focus on operating system, for example, and let's really have a dialogue with Apple and Google, with their practices related to their operating system. You know, let's not take 7 years, but let's take at least a year and have a dialogue and have a dialogue with all users, with developers of apps, with end users, etc. And really look at what are the issues on the specific markets and what can be done to resolve any exploitative abuse, potential exploitative abuse, or any potential, you know, foreclosing conduct. Similarly, if data, well, consumer, you know, personal data and the combination of personal data can be done for several reasons. Let's say it's for advertising purposes. Why don't we look at the online advertising market? You know, advertising in traditional markets is heavily regulated in many countries. Okay, why not look at the online advertising market, spend some time, not 7 years, but not 2 months, and look at this market and see what are the problems, where is the exploitation, where are the foreclosing conduct, and let's address those. You know, the issues that will arise in operating system markets or in the advertising markets are not the same as those that would arise in intermediation markets, for example. And I haven't looked at when I started, but I think I used my 5 minutes.
Thank you very much, Valerie. No, this was very useful. Thanks again. And you touched on some very interesting points that I would like to raise in the main discussion. So thanks. Maybe I just give now the floor to Per Karlsson, who can also offer us his own point of view, being an expert in this field. Per, feel free, the floor is yours. Thank you.
Thank you very much for the invitation. And my background is that I've been working with the competition policy issues for like 25 years or something like that at the ministry as legal advisor there and as chief legal officer at the Swedish Competition Authorities. That is my policy background, so to speak. And now I'm in private practice again, second time. I have analyzed the DMA from a Nordic competition and innovation policy perspective. Google asked me to do so, and I have had the input and comments on my work from Sten Nyberg, my former colleague. He's a professor of economics at Stockholm University, and I also been working with Dagner Sabokis at Stockholm School of Economics. One obvious observation is that overregulation or regulating markets in too much detail can seriously harm the innovation climate, as is a key rationale for the European Commission's own better regulation agenda. Sound regulation should be grounded in economic analysis and adapted to the relevant economic context. I'm not against the market regulations as such. I have seen that in my former capacities as a complement to the competition rules in Swedish deregulation over railway, postal services, telecom and pharmacies. But it's very important that a market regulation is designed in the right way. So economic regulation or market regulation can address market failures and make markets work better, but too much or badly designed regulation will achieve the opposite and stifle growth and economic progress. And if I may say so, the DMA does not seem to be a typical market regulation, in my opinion. It prescribes one set of rules across markets with very different economic conditions and business models without recourse to exemptions. And another observation is that competition law enforcement possibilities does not seem to be exhausted in this case, as they were in my Swedish examples of the railway, telecom, etc., pharmacies. And the definition of gatekeepers in the DMA is not tied to any competition concerns and is based on thresholds in absolute numbers without connection to any relevant market. It's a little bit odd, I would say, from my background. The gatekeeper criteria give rise to threshold effects, and as a result of the criteria's definition and design, it may counteract a level playing field. And the DMA is also at risk of hitting the innovation climate particularly hard in the Nordic countries and may have a negative impact on incentives for Nordic startups. The region is a leading hub of innovation in Europe. There are some official numbers on that, and you may have heard of Skype and Spotify, for example. Therefore, the effects of the DMA will be particularly problematic for the region. The Nordic competition authorities, 5 competition authorities, it's Sweden, Norway, Finland, Denmark, and Iceland. The Nordic competition authorities have also jointly expressed concerns about the impact of the DMA on incentives to invest and innovate. Integrated and innovative new services provide massive consumer benefits, and these benefits are at risk of ceasing as a result of the DMA, especially complementary innovations compared to standalone innovations. Complementary innovations to digital platforms are at high risk of being discouraged. It's another observation that we have made. And the DMA offers no direct consumer benefits. I heard from Tiemo that he was asking for that, but it's not clear to me what direct consumer benefits in contrast to other regulations such as electronic communication concerning roaming and number portability. That's pretty obvious consumer benefits, but here it's not clear. Another thing that have been addressed here in the panel is regarding acquisitions. And from my point of view, for example, merger control should be very restrictive, I think, and not used very often, only in rare cases. And I think it must be recognized, as has been by the Swedish government in several papers. I've been involved in these papers myself, and bills to Parliament, where it has been recognized that acquisitions are also important drivers of innovation. The contrary to killer acquisitions. It's a lot of benefits from, and it's an important driver in innovation, and that motivates innovators and perhaps take the next step with a strong company with financial resources. And it might even be driven by the fact that they might be bought up at a later stage. That's an important driver for innovation. And my last point is that there is also strong rationale for justification of rules in the same way as there are already justification rules and have been for like 60 years in Article 101.3 and the case law under Article 102 regarding abuse of dominance. So these are my main points. I don't know if I've used my time already, but it was.
Thank you.
If you want me to elaborate on any points, I'm happy.
Thank you, Per. I think this has been great. I think also in the interest of time, it's good that we go to the next speaker so we can have a lively dialogue. But I have noted a few points that you made that we will pick up on later, especially on innovation and the innovation climate, as you said. That's also key to the recovery that we are hoping that the DMA will contribute to in the EU. So let's touch upon this later. Thank you again so much. I'll just offer the floor to Karina Stan from Developers Alliance. And Karina, thank you so much for joining us. There are a few topics here to tackle, and maybe speaking at the end helps because now from all our panelists, we have heard, different issues on gatekeepers, the scope, the enforcement, the definition. But I think from your point of view, it will be extremely interesting to hear about, the startup environment and how developers working with so-called gatekeepers, how would this regulation impact the people that you work with, and perhaps the trust of consumers and services. Off to you, and listening would be great. Thank you very much.
Thank you. Thank you for inviting me to such a timely discussion. Well, I used to say in many conversations that, DMA is not a regulation about gatekeepers, but it's about, from our perspective, a regulation about digital ecosystems. And by the way, seeing the last IMCO draft report, I think we have a confirmation on that. But we see the DMA not in isolation, but as an important part of an industrial strategy and within the general regulatory landscape at the EU and national level. So let's not forget that for many businesses, such for software developers, they used to represent in many aspects 27 markets. And I know there is a lot of excitement, among academics, competition law practitioners, economists, and other experts, about this shift to ex-ante approach, which is supposed to top up competition policy. The tendency being, I observe, to use it as some sort of convenient shortcut. There's a lot to talk about, but my mission is to present software developers' perspective, and it's quite a pragmatic one. For us, it's all about the cost of doing business and barriers to entry in this particular jurisdiction in the EU. So, cost of doing business. The political decision we see is already made. The regulatory option is already chosen. So I'll just stick to the two main aspects that the co-legislator should consider during this critical phase of the legislative process. Of course, if they want to avoid unintended consequences as much as possible, because remember, it's about digital ecosystems. And also, if they want that the regulation should benefit to all business users, and I underline all business users. So first of all, and I'm happy that I heard a previous speaker mentioning that it's about preserving the incentives for investing, for innovation, and the mechanisms for value creation. And second is about proportionality and efficiency of the regulation. So we conducted a developer survey in spring that showed that the top important elements for developers when they make the business decision, a very critical one, to choose a certain ecosystem to do business within, is support tools and services and platform stability. So this is what is important for them, the most important. Therefore, we recommend caution, in implementation of, several obligations that we see in our Article 5 and 6. We urge the co-legislators to consider the implications for the stability of these digital ecosystems, both, from a technical point of view, but also from an economical point of view. So we support strong safeguards to ensure the security of both hardware and software. We heard we are encouraged on some good news from Council's approach in this sense. We welcome any amendments in this direction. What is important is to see that the DMA will force the gatekeepers to make significant changes to their business models in Europe. They will change their monetization strategies, that's obvious. What exactly will those be? And what the effects will be on business users and consumers? It's a great unknown. It's a big question mark. I recently heard during an event, Andreas, the president of Bundeskartellamt, he was referring to the DMA and talking about, it's a one-size-fits-all and so on. And I remember clearly that he said that it's, I quote, unclear what the consequences would be. But what is clear, though, from our view, is that a degradation of features and services that are currently available for developers within these digital ecosystems will negatively affect their business and their efforts to reach a global market. And the cost of doing business will be much higher. For example, they have to pay more for marketing tools or to pay for support services that currently are free or low cost. And it's likely we can see that the new law will create barriers for those wishing to reach markets outside Europe. So what we are saying is that the implementation of the obligations should not lead to dismantling these mechanisms that allow value creation within and on top of the platforms of these ecosystems. And I know that there is a strong opposition to efficiency defenses, but what should not derail from the objective of certain provisions and in general of this regulation and ignore the intent, the basic intent, those to help business users. And again, I underline all business users. So the focus should be, in how do we implement, what do we want to achieve here? So the focus should be on the effects on business users and also on consumers if lawmakers will decide in the end to consider them. And not only to tackle, a big player and to impose some kind of redistribution of market shares. I think that's the wrong objective. So, and we see also a clear tendency for mandating specific business models and design choices. And this is quite intrusive approach. And I think will not only constrain innovation opportunities, but it might lead to a lack of differentiation and diminished inter-platform competition. But also it will raise difficult problems in implementation. I like to see, the regulators doing product design. So moving to my second point very quickly, on efficiency and proportionality of the regulation. So the big issue here is there is no clear vision of how these self-executing obligations will work in practice. I didn't hear clear answers to that. So nevertheless, I saw the IMCO draft report emphasizing the self-executing nature of these obligations. So legal clarity and certainty are key. So the companies should be able to foresee which regulatory requirements they should comply with. And therefore, what we recommend is just, adjusting Article 5 and 6 around clear principles for each type of services or business practices that are seen as problematic, because clearly one-size-fits-all solutions are not suitable. There are so different business models. So tailored remedies, which are based on these principles and established during a proper regulatory dialogue, this will not only avoid unintended consequences, but also will ensure that the regulation will actually work in practice. So in this sense, I can see German-UK approach is more plausible. And last but not least, because I mentioned the 27 markets instead of one digital single market, all harmonization should be pursued as a key objective, because, well, the legal base, Article 114 obliges, and not to be undermined by ambiguous provisions, inappropriate enforcement mechanism. Here I see a lot of work to do for co-legislators, to find a viable solution on that. So I don't know if I exhausted my 5 minutes, but I will conclude with just the food for thought on, for the co-legislators, especially for them. What is the message the DMA is sending to the current and future investors in EU digital markets, and also to the ambitious entrepreneurs that could be considered at some point on unclear criteria, as the text currently stands, as foreseeable gatekeepers? So, and of course, all of this is in the context of economic recovery and need for growth and innovation. So again, let's take a step back and look at the whole picture. Thanks.
Thank you a lot, Karina. This is very helpful, and having listened to all our speakers and you now, I think there is some broad consensus on some of the issues that you have all touched on. Unfortunately, Mr. Wölken from the Parliament and Mr. Duarte were not able to stay for the whole of the discussion, but now we will be able to tackle some of these, looking more closely into the regulation. And specifically following up to some of your points here, you all somehow agree that there is lack of clarity on the process, but also on regarding the scope of the regulation itself. So I think some of you have mentioned Articles 5 and 6, and which are about the obligations for gatekeepers and obligations for gatekeepers susceptible to being further specified. That's Article 6. And I think it would also be interesting to look a little bit and hear your points about Article 15, paragraph 4, that suggests that moves the focus to foreseeable gatekeepers who will be subject to Article 5 if they enjoy an assailable market position that can be enjoyed in the foreseeable future. In that case, the article specifies that you may be subject to Article 5 obligations to some extent. So, I mean, even from my point of view, who I'm not an expert on competition law or a lawyer, I think that there seems to be a little bit of lack of clarity there, because we are having this discussion within the context of having a strong European recovery post-COVID-19, and 99% of the single market are SMEs. So how do you address this lack of clarity in terms of foreseeable gatekeepers, because at least to my mind, it seems that all SMEs would like one day, hopefully, to become gatekeepers if possible, because that's I guess also the part of the whole process of scaling up and and growing European unicorns and startups, as Thierry Breton, Commissioner, has mentioned previously. So I would like to maybe ask you, Valerie or Per, to comment on Article 15, paragraph 4. What does the regulator hope to achieve by inserting this relatively ambiguous definition of foreseeable gatekeepers? Who are the foreseeable gatekeepers, and how can you make sense out of that? Valerie, please.
That's a difficult question. I agree with you. So the DMA, or its Article 15, gives a lot of discretionary power to the European Commission. Okay, on the one hand, we can understand, because they want the DMA to be flexible enough and be future-proof, etc. But at the same time, it poses a lot of uncertainty on current companies. Whether what's the risk for them of being designated as a gatekeeper, increasing the cost of doing business, as Karina was saying. And my first, I'm going to maybe, step a little bit aside the question. So I agree with you, there's a lot of uncertainty, a lot of discretion left to the Commission. And also, I recall my first reading of the DMA, I found this whole process quite convoluted. The obligations in Article 6, I'm not quite sure I yet understand how it's going to work. But anyway, that's a little bit beside your point. And I don't know what else to tell you about Article 15. I agree with you. It gives a lot of discretion for the European Commission, and which is on the one hand understandable, but on the other hand, problematic, given the uncertainty it leaves to the business. And maybe Per, you can give your point of view as a lawyer.
Yeah, I mean, especially on the issue of enforcement, please, Per, off to you. Yes.
Okay. I would like to comment on Article 5 and 6. I haven't done that yet. It's clear to me that, for example, self-preferencing could be either anti-competitive or pro-competitive, depending on the situation. I think all economists would agree upon that. And therefore, I think that it's pretty odd that it's going backwards in competition policy, what we have achieved with the economic approach, like for 20 years now, and we're going backwards in an ordoliberal per se rule way, I think. So I think it's very unfortunate that we list a lot of behaviors from competition cases that, I think just because it has been questioned by competition authorities, certain behaviors in a particular market doesn't mean that it's something that could be designed in an ex-ante regulation, because that is requires other foreseeability, for example. So some cases are better designed for competition enforcement, strict competition law enforcement, and has to be dealt with on an individual basis. But ex-ante regulation, if you put criteria that will apply to all the gatekeepers here, as such, is not particularly well designed, I would say. So it's going backwards, what we have achieved for 20 years, in my opinion.
Thank you for this. Karina, I was hoping maybe, considering this this part of Article 15, paragraph 4 on the foreseeable gatekeepers, and and also at the same time juxtaposing this with the strong need for a COVID-19 recovery. 19% of the single market is SMEs. I was wondering, and SMEs in this field, digital SMEs especially, are interested to scale up in this single market. And we were talking about the cost of doing business. So I was wondering, how does this message about foreseeable gatekeepers, what is the message that the DMA sends to developers out there?
Well, imagine, as I mentioned ambitious entrepreneurs, because these are, software developers that have, startups and they want to scale, of course. And in digital markets, it's all about exponential scaling. So imagine coming with a great business plan. They have a great product and they have a great business plan, and they are looking for to finance, and they are talking with VC, and they present all of this, and the VC will ask, oh, okay, where are you, in which jurisdiction are you operating? And they say, well, you are European, and maybe East European, I'm not from Eastern Europe. Yeah, and there are a lot of ambitious entrepreneurs there, and bright software developers. Yeah, so, and of course they will look, I mean, an investor, and especially, when it comes to private investment, they will look at the whole picture. They will look at all the conditions in that jurisdiction, including, the legal requirements. And of course, they will look into perspective, because they are investing, on long term. And they will see, okay, plan B, an acquisition. Well, we should cut off that, or it's, less likely, because there is quite, I mean, it's continuous scrutiny on that, no matter the situation, the case. In many cases, you have on acquisitions, I'll derail a little bit, but on acquisitions, I have to say, there are not all killer acquisitions. And in many cases, I know from software developers, it's sometimes all about the team. It's a great, there are great software engineers, they are working great as a team, and they, the sole purpose of the acquisition is just to get the talent. So no killer acquisition there. I don't think, the authorities should waste time in investigating and money in investigating everything. But coming back to, to the legal conditions, for scaling up, of course, at some point, as I say, it's exponential. At some point, you will be under the, this, there will be a potential foreseeable gatekeeper. So, but it is not clear. I said that before.
Yeah.
If we are reading the text now, it is not clear, and I'm not a competition lawyer, but it's still you cannot say when you will. It's all very it's discretion of the authorities. I mean, Digicom or competition authorities. We don't know in the end who will be who will do that. But so you are at the discretion of the authorities. And so the future is, because you will need to adapt products.
Exactly.
So
On
from
this
an investment point of view, this is very important, because if you have a successful product, but at some point you will have to adjust it, or you will have to get rid of some products or services, ancillary ones, just because you will be in this position as a gatekeeper, then yeah, I think it's better to move, your headquarters to. And we have examples. I mean, a lot of startups there, when they are attaining a certain level, they are moving to other jurisdictions, US, Israel, even Asia.
Indeed, that's another thing that can happen and has happened in the past. And thinking about the Nordic point of view here, that's very interesting. Maybe just to turn to Per again. Per, Karina just was mentioning about this, how different services qualify differently. I was wondering, maybe, and this comes to your point about innovation earlier. we have some big players that they have quite a few services that they're offered across the board, and it seems that the current draft of the DMA at least to my point of view, it seems unclear whether the regulation is focusing on the definition of the service or a good definition of the company, because other experts have argued previously that Articles 5 and 6 they come from previous competition cases, or they're very closely linked to previous competition cases. So I was wondering, what do you think, like this regulation does enough to distinguish between services and companies? And perhaps Valerie would like to comment on that too, but maybe starting from you first and offering the Nordic point of view. I hope you haven't touched on this already. If you would like to raise this again, thank you very much.
Thank you, Andreas. What I meant was that Article 5 and 6 is like per se rules, in my opinion, which means that there are no justification amendments to the rules as I'm aware of, and which means that either if you fall under the gatekeeper definition, you have to adjust your behavior to Article 5 and 6, which means that it might be at risk that a lot of innovations cannot be dealt with and it cannot proceed with, because companies that are under the gatekeeper definition may not be possible for them, for example, to buy up an innovative company that have designed especially this is the case with what I will call in my paper that is not finished yet, but complementary innovations. Where, for example, a value could be added to an current platform, and they may even, an innovator may even go to various platforms and ask if they are interested in this innovation to develop something that would benefit consumers and end consumers. And then it might be the case that a company, a platform that is under the definitions, maybe either of them cannot proceed with that potential buy-up because they may not include that in that digital platform because of, for example, self-preferencing. There are clear rules against self-preferencing, which might be in some cases pro-competitive, in my opinion. Yes. So that is an example that I can say.
Maybe.
Sorry.
Oh yes, please, Karina. Yes.
Yeah, because I mentioned, in acquisitions on, talent acquisition, but also, yes, it might be sometimes a startup, developing a certain technical feature, so it's not, a product in itself, and it might not be, in the end, a product that, will go to the market. But it will be, a very good technical solution, a feature that might be very useful to optimize a current product or a future product in the making. So bringing, more value to that product and indirectly more value to the consumers. So we might have these cases, and that's not an isolated example of how innovation is happening, because it's not happening in one place. You gather from a lot of parts and you aggregate, and we should not stop this.
Absolutely. Like you said, I think there is a big dialogue within the ecosystem. And now I guess our point is how to bring this dialogue with the regulators too. And I see, I just wanted to ask Valerie if she wanted to come in on that. Otherwise, I can ask another question. Valerie, would you like to comment on any of the inputs?
Yeah, yeah, of course. So you mentioned indeed that so some of the obligations in Article 5 and Article 6 can be directly linked to past or ongoing cases. Okay, so in each of them, you can allocate to one or two of the main companies that we know of. Okay, so 5A, for example, would apply to Facebook and Google primarily. The question is, has anybody thought about how it would apply to, the others, the other gatekeepers or potential future gatekeepers? What is, take 5B, that's, really targeted at Amazon on its marketplace, for example, and the prohibition of wide, most favored nation or price parity clauses. It allows for the narrow ones. Which brings me to another comment. How will that interact with the new, the vertical regulation being reviewed right now, where there are discussions as to whether MFN clauses should be considered, hardcore restrictions or not, etc. There will be a lot of confusion regarding those practices, and from from the companies' perspective themselves, it will be complicated. How will anything apply? You can imagine also the mess it can make at at enforcement stage, at national competition authorities level, at court level. How will all of that be applied? If you look at 5C, this is typically clearly connected to the current investigation into Apple and the App Store rules, etc. And we could go almost, it's true for many of the, not all of them, but for many of the obligations, which gives you a sense that this regulation was made as, here's a list of things with investigations that are ongoing or that have been happening, like self-preferencing, if we look at the Google shopping. One reason it took so long, those investigations took so long, there are probably several reasons, but one of them, indeed, is that those conducts are not necessarily harmful. They're not unambiguously harmful. This is why now it is surprising to see them in the list of do's and don't. If it takes several years to a large competition authority to come to the conclusion that that particular conduct was potentially harmful, and for some of them, we haven't come to a conclusion yet. It means that it's not obvious, and it is surprising that now the Commission wants to, to prepare to prohibit them all across, all business models, all type of companies, as long as they are big. So I find it a little bit paradoxical. You can make the parallel between, the discussions we have in our little world about the distinction between a restriction by object and a restriction by effect. A restriction by object is a restriction by object because there are precedents, because the economic and legal literature says that in most cases it will be harmful, like agreements and price lists and things like that. But none of these obligations here, none of those do's and don'ts are in that particular situation. There's no consensus, on most of those obligations there. So this is something which I find quite problematic. Yeah.
That's super interesting, and maybe I think that also links us very well in our discussion with the question about enforcement, because Tiemo Wölken earlier suggested that it would be crucial to see more channels of cooperation with national competition authorities in terms of the enforcement. But you know, and he also said that any regulation is as good as the enforcement that comes with it, and I tend to agree with that. Although I'm not a policymaker like Tiemo, but I was thinking, you know, wouldn't it? What would be the potential effect on enforcement in that case when you have, you know, you have a regulation that a few experts, a few people, even policymakers have expressed concerns about its phrasing, then how would that be enforced? Would that be better enforced at the national level when there are so many concerns at the EU level? And perhaps, you know, just to push the discussion a little bit further, what could happen? And I'm asking you as being, you know, experts in this field previously, what would happen if for example, in the absence of a regulatory dialogue, there is no clarity, and then many of these gatekeepers take the Commission to court? I mean, would there be any other solution to that? I mean, in terms of practice, previous practice, what does happen normally when there is lack of clarity and the investigated does not have a clear idea about how to respond? Wondering maybe if Valerie or Per have something to say to that.
Very quick remark. I completely agree with you. I think it will be problematic. We already observe a fragmentation of, you know, of the way, you know, some countries, member states have introduced or are about to introduce laws. Decisional practice. If you look at enforcement, look at the Booking.com saga a few years ago. The Commission refused to intervene. It should have taken the case, it didn't, and then left, I can't remember if it was 11 or maybe 16 NCAs looking at that case. 3 were leading, Sweden, France, Italy, with the EU, you know, within the context of the European Commission network, overseeing what happened. It was a fiasco, complete fiasco. You know, they designed some commitments, and then all of a sudden there was a new law in France prohibiting, you know, MFNs, etc. So it tells us that, you know, having those issues looked at only at the level of NCAs doesn't work. It has to be together. They have to get together to discuss what should be you know, maybe imposed or negotiated, at least with maybe the companies at stake in, well, under review, at least at the European level. I mean, those markets are, you know, most of them are worldwide, not all of them, you know, not all of them, but so it is, you know, in terms of enforcement, I think the proposal is not ready yet. It hasn't really sorted out all the issues that could arise, and I think there's a lot of discussion to be had. I'm not I'm not a lawyer. I'm not a judge, and those people have a lot to say about what could happen. You know, and they are important to listen to in terms of unintended consequences.
Thank you very much, Valerie. Per?
Well, I think that fragmentation could be a problem as in the booking case, but it's not what I foresee with the DMA itself, because that's a commission. I mean, it's a commission product that will be enforced by the commission. And it's pretty little bit, I'm curious about the Swedish Competition Authority, my former employer, actually, because they were part of the joint memorandum of the Nordic competition authorities warning for that a list of articles of certain behaviors could be either pro-competitive or anti-competitive, same as I said. And the 5 Nordic competition authorities made that statement together, and they also pointed at the risk of harm of innovation. On the other hand, now the Swedish Competition Authority, and I heard the Director General is asking for some kind of national DMA, so to speak, which would cover, I mean, national gatekeepers. And that's pretty odd, because on the same time as they in September last year were pretty warning for EU dimension, gatekeeper definition, and this kind of lists. They now asked for this spring, they asked for something. We want something also because we don't have any rule in the DMA, it's only the Commission. We also would like to have something like this on the national level. It's interesting that they have given that message even formally to the Swedish ministry and the government's office. So it's a little bit tricky though to understand where you're going really on this point. But I think that should be clear, in my opinion, that the DMA is the DMA and it goes for the whole EU. And I think I'm warning about the DMA itself, though. So I'm even more negative to a national DMA, so to speak, enforcement.
Okay, yeah. So you think that would make things even more complicated, having a national DMA and an EU level DMA? Absolutely, yeah. No, I mean this is super interesting from in terms of the enforcement, because you know, then there's the question of cases, and previously Valerie said, for example, cases can last in some cases up to 7 years. So I mean, how and then I guess this creates a regulatory environment that is pretty complicated for. It's complicated as it is maybe for big businesses, but then it gets even more complicated and increase the cost of doing business for the smaller ones. Is it? How would you react to that, Karina? Is that perhaps also a concern from the SMEs, from the smaller ones, developers, in terms of how the business model of the big ones could be impacted and increase the overall costs? I think you commented on that previously. I'm sorry if I'm asking you to do the same again.
Well, yeah, I already touched that point, but just to come back, as I said, it's all about ecosystems and how they will be transformed. And of course, I mean, I will not say, I mean, I will not present you some kind of apocalyptic, you know, vision. Everybody will go bankrupt and will go into, you know, other businesses. No, they will keep developing software, but under very different conditions. And for example, for mobile app developers, I mean, if we will have a dramatic change in the iOS environment, then they will have that. And of course, you know, those that there are, for example, established brands and you know, they have a certain size, it would be more easy for them. You know, some might have their own app store. But for others, I'm referring to the small ones, it will be harder and harder to reach a global audience, and they will pay more for, I mean, for marketing, for example, just to reach that audience. And I mentioned again, I because it is very important, the support tools and also the support for operating systems. If this won't be provided, or you know, it would be more. It would be a completely different landscape. I cannot look in the crystal ball and say. Not even the regulators can tell us what exactly the vision is. So you can imagine that it is a lot of uncertainty for European development. So we need to provide, you know, this certainty, this vision. I mean, let's tell them you want to, I don't know, 10, 20 app stores. You want, I don't know, to develop a European operating system. Tell them something, you know, give them your vision. But otherwise, what we can see is only a raise in cost of doing business and accesses a global market. And I will also add, I mean, this lack of vision. I heard, you know, a point raised during the Flores competition conference. You know, that markets complain that markets don't respond as expected. Well, there is no surprise about that, and that's why it is a huge burden on the co-legislators to find the right trade-offs and provide the right incentives, you know, to ensure, you know, at least the right direction and get closer to the desired outcome. And it's quite an intrusive interventionist regime, regulatory regime, what they are proposing. So we cannot speak about free markets here. So the outcome, that's why I said, even from investors' point of view, the outcome is a little bit worrisome, because there is no incentive for economic growth, but for stagnation, unfortunately.
Thanks. That's a dire outlook, but it is what it is. Maybe just to sum up a little bit, because I'm also being aware of the time that we have been speaking for a while. Just to sum up some of the points we have made here, and Tiemo Wölken has previously mentioned that the need for a future-proof, more flexible framework for effective enforcement. We have also mentioned the streamlining designation process. So this is about the definition of gatekeepers, and clear rules on interoperability. As you all have said, this is an ecosystem, and there is apparently a lot of dialogue taking place between the small and the big ones in the ecosystem, but maybe there seems to be a lack of dialogue with the regulator themselves. And perhaps, coming to all the points that you have mentioned here, I was wondering, according to you, and please feel free to brainstorm as much as you like here, what kind of EU level action would help to bridge this dialogue? Because it seems like these concerns, gatekeepers or others, are not going to be able to share or to bring up for consideration by the Commission. So I was wondering, and this is a totally brainstorming question from my side, what EU level action would help bridge that dialogue? How can we perhaps fill in that gap and create some way where concerns can be staged effectively, and there's a proper dialogue taking place between regulators and regulated? And feel free to avoid answering that spot on if you're out of answers. But anybody who would like to reflect on that, please take the floor. I don't know if that was super clear.
Just a question: are you querying specifically about interoperability issues, or in general having a dialogue?
Yeah, so I'm thinking,
any of these?
With all these issues that have been mentioned on interoperability, on streamlining the process, these are all issues that somehow need to be discussed, and this discussion would bring about an effective enforcement too, where there is legal clarity, and also create the kind of environment we want to have for in a post-COVID-19 recovery in the EU. So I was wondering, what sort of solutions, if any, would you suggest here about how to bridge that dialogue? Obviously, this is the $1 million question, so it's a pretty hard one. I don't know if you would like to reflect on that, or if any of you have any ideas.
Well, in my view, this new competition tool that was proposed last year in the inception of all that process was, in a way, a tool allowing such a dialogue between the regulator and those being regulated. I think there are jurisdictions that have this market investigation tool already, like the CMA and others, which means that you can draw experience from that. You can know what works and what doesn't work. Using that knowledge and using the feedback from the market that the Commission had, I think it was a good first step in trying to, as you were saying, bridge this gap. Those digital markets, some of them are quite complicated and technical. You don't need just economists and lawyers to resolve that. You need people who know how to write code and who know algorithms and stuff like that. So you need on the one hand to be equipped and to have this constructive dialogue. Interoperability in itself, that may sound like, for example, taking your illustration might be appealing, but there may be circumstances when it is not feasible, when it has the consequences of stiffening chilling competition rather than making it more vibrant. So that's my view. I think a framework in which you can have a dialogue, you can organize a dialogue between the regulator and the regulated companies within a framework, of course, not in the abstract, on particular issues, that may not concern all of the digital platforms. What is relevant for, the advertising market might not be relevant for the ecosystem and the operating system, as I mentioned earlier, or cloud services, etc. So this is my view, and I'll stop there.
Super, thanks a lot. And Per, over to you. Yes.
Thank you for the question. I've been working with politicians for many, many years in the government office, and I feel that in this particular case regarding the DMA, it's political pressure here to do something. It's very strong, I would say. So my suggestion would be that the decision makers and the politicians would listen to the counterfactuals and what would really be good for creating a level playing field in this sector regarding digital markets. I mean, I think it's a very complicated issue actually, and I hope that they will listen to the experts and academics and really take into account all considerations that have been made actually. So that's what I hope. Not only for political reasons doing something that could be counterproductive in the long run. So I think there are risks here. That's what I see.
Thanks a lot, Per. For this kind of discussion between experts, academics, you can rely on us as think tanks. This is going to be this is our bread and butter, so to speak. But absolutely, yes, a regulatory dialogue seems to be something that quite a few people in this room are asking for. And maybe on this point, just like to bring in a question from our audience by Miss Whitney Clark, and I'm also aware that we're now past the time, so I'll try to make this as quick as possible. So Whitney is asking, she says, you mentioned the need for a more inclusive system, but wouldn't that be something that could be easily coordinated through the request of European standards? And she mentions, for example, she says, how does the DMA intend to make use of the standardization strategy to capitalize on standards for the single market? Maybe to unpack this a little bit. Oh, Karina would like to answer that. Okay, I'm glad it was clear already. Thanks a lot, Karina. Off to you.
Well, this is a complex problem. I mean, standard issue are mostly related. The question, I think, is mostly related to interoperability and supportability obligations. And on interoperability, I think it is very important to choose, what makes sense. You cannot have a one-size-fits-all solution. That's very clear. And also, it is an option, and should see what makes sense in each situation. Should we use API? Should we standards? I saw in the IMCO draft report that the regulator is thinking about standards. But standards, they are not developed overnight, and usually it's a bottom-up approach, and it needs to be also a commercial value for that, and use cases based on market demand. So, and I think we should learn here. The regulators can learn a lot from the challenges and specific cases, like for financial. We have the financial and banking sector. It's a narrow application, but we can learn a lot from that. From PTS to implementation, the UK open banking project. So, but imagine if there are still challenges there. I mean, they are not 100% success. So if there are challenges there, where is a limited application to just one sector, which is quite homogeneous, then it's food for thought how we work in practice, with other services. And we hear calls from the Parliament, interoperability, also on core platform services more than ancillary services. And I think we should take it easy. I mean, I said it's a risk of, erasing the differentiation between services, even if we will, let's say we will find a standard and we will implement it, top-down approach, but we will erase any differentiation between services. And but also it will need, we hear also, interoperability for one side, it should be two-way, for example. If we mandate continuous and real-time interoperability, it should be two-way. And again, the economic value, we should always think about that, and the market demand. And so it is very complex. And I was thinking during the previous comment, about how complex is in implementation. For example, again, I'm commenting on the IMCO draft report. I saw a reference on multi-homing, newly introduced. Well, on multi-homing, it's all about substitutability, but I don't hear what are the criteria to appreciate, what is a substitute, what is complementary product.
Yeah.
So it's a these are complex elements, and in the end, we know that market demand always dictates the fate of services. It should not be the regulation.
That's a very good note to finish here. But before we finish, and I think we're almost there, I'd just like to ask you to give you a last opportunity to all of you here, if you would like to give some final words to your inputs today. What would that be? And if you could sum up your reactions in a couple of sentences, that would be great. Maybe I can pick up on Valerie already, because I see here she's laughing.
Sorry, I think I will just I don't know if it's still possible, given where the DMA is in the process with the Parliament and etc. But I would really urge for refocusing on a different tool, not this list of, in French we would say a potpourri of or a mixed bag of obligations that clearly are targeted, each of them are targeted at a specific companies already, and move away from that list and reprioritize something that looks more like a market investigation tool, which, with the use of, some NCAs have argued also for the use of interim measures. If you're worried that some things are going too fast and very detrimental in market, use interim measures and then start a thorough investigation into a market. It doesn't have to last 6 years. It can last 1 year, let's say. They can be clear deadlines, and invite, but that allows a dialogue that is not adversarial, but it can be there can be contradiction between regulators and the regulated companies, but also the users of the regulated companies, with an obligation for all market participants to cooperate, and we know the Commission already has those tools. And trying to in the end, if necessary, to frame remedies that would constrain the conduct by the gatekeeper firms in the in a broader context, with may include recommendation to other authorities. That was it.
Thanks a lot, Valerie. Per?
Well, thank you for the opportunity to be part of this excellent event that you have moderated. And I just want to say that I need to leave the meeting now, but first I want to say that my analysis is that the DMA, from a Nordic competition policy perspective, innovation is at risk, I see. That's my point here, and I just want to emphasize this the last time here in the Excellent. Now I'm leaving. Thank you very much.
Thanks a lot, Per. Apologies for keeping you longer. Karina, any last words from you?
Yeah, so just a last call to, to the policymakers, don't destroy the mechanism for value creation and innovation. Yeah, it's a difficult exercise, but we hope that they will find the right balance, with all these trade-offs. We're not there yet, unfortunately. And also, it's all about accountability. Please assume the economic consequences of, these regulatory interventions on this critical market. And I think, in 10 years, we will be able to see if this cohort of regulations, because it's not only about the DMA, so including the DMA, we'll see if this will be a success and will bring more growth and innovation. For the moment, we are not convinced.
Not yet, not yet.
So
We're doing what we can.
There's a pessimistic tone, but it's just a call. Let's not end up with a pessimistic outcome.
Thank you very much, all of you. Thanks for staying for that long. I didn't envisage that this was going to last longer, but thank you so much for staying longer. And we will circulate this public policy dialogue also later on our website in a recording for others to watch who were not able to join, and feel free to circulate also with your colleagues. And we will take note of your points, and perhaps they will be very useful in helping us also advance better recommendations for the Commission's work. So thanks a lot for joining us, and I wish you a great day. Thank you.
Thank you. Have a good day.
Bye.